Miguel Sousa Ferro, welcome to Digital Markets Research Hub. You are known among antitrust law academics and practitioners as a very impactful figure in the area of private enforcement, primarily of Portuguese competition law, but more generally of EU competition law, both on your academic side and your practical side. So I wanted to use this opportunity to invite you to discuss this issue, this rapidly evolving issue. And as a first question, please offer to us your exposition of the development of private enforcement of competition law in the European Union.
Right. Well, thank you so much, Olis, first of all, for this invitation. It's always nice to get to talk to you and to debate these ideas with you. I've had a couple of opportunities already, so I'm very thankful that you've invited me back to have another conversation with you. I think that the main fallacy that we have when we think about private enforcement and the way that it evolved is that we used to think, oh, there is barely any private enforcement of antitrust rules in Europe before the damages directive, and that's simply not so. It's true that the studies done at the time when these discussions were taking place at the beginning of the 2000s, those studies didn't find a lot of cases, but later academic research showed us that they just were looking for the wrong things. It was too focused on actions for damages. And the reality of private enforcement, there have been studies done for Portugal, for Spain, for Italy, etc., that show this, is that you had tens and tens of cases going on. In Portugal, for example, since the 80s, which were antitrust private enforcement. They simply, in the majority, were cases where antitrust was raised as a shield, and therefore it didn't come onto the radar of those studies that were done later on. But you certainly had already a lot of experience with courts being confronted with the need to apply competition law, both national and EU competition law. But indeed, you had very, very little success in obtaining damages. And that part, the studies done in the early 2000s were spot on. In Portugal, for example, you had maybe 7 or 8 actions until the damages directive that got some small amount of damage. And even then, it was basically symbolic. So I absolutely agree that the system was not working until the damages directive. And it was not working throughout Europe. It wasn't any particular feature of any single EU national legal system that made it difficult for work. It really was shared difficulties amongst all the member states. And that made it absolutely imperative to have some kind of harmonizing intervention that would solve those problems. And that's what the damages directive tried to do. The big question is, was it successful and to what extent? I think we can say, yes, it was successful, but not fully so. And of course, nobody expected it to be perfect. But it has highlighted the fact that some of the issues that were identified as being obstacles were absolutely crucial, and they have been solved. I'm thinking particularly of the problem of limitation period, of the problem of the risk and the incentives that you need to go past those risks. For example, when it comes to the establishment of presumptions of causality, this kind of thing. But there are still a lot of areas that need attention, and we'll probably have the chance to get back to that later. Right now, what we're seeing throughout Europe is an attention on follow-on actions and a multiplication of many, many individual actions or gigantic bundled cases, depending on the features of each jurisdiction. It's really amazing that you need to follow the economics to understand why things happen the way they do. Why do we have thousands and thousands of cases in Spain and a few gigantic bundled cases in the Netherlands? And it's all about the economics of the judicial system and how it works and the incentives that it gives its operators. But at the same time, these cases are being done basically in follow-on of a few decisions. If you truly look at it, you probably have about 10 cases might be too much if you think that trucks cartel is just one case, for example. And then throughout Europe, you probably have 10 cases being litigated in any significant number. Then you have the consumer side in the Netherlands, in the UK, in Portugal, especially, a little bit in Slovenia. And that has been a completely unexpected, I think, surge of attention to that area. And those are interesting because there you've seen standalone cases a lot more than in the non-consumer side, where you tend to have smaller damages and therefore less of an incentive to invest in everything that it takes to create a standalone case. In the consumer side, with opt-out, it has been possible to do standalone cases, and that expectation of the damages directive that there wouldn't be practically standalone cases has been subverted in that field.
Amazing. And I propose we will revert to some aspects of types of private litigation in Europe, and maybe we can look at some comparative aspects. You mentioned already stark differences about how the judicial system is being historically developed in different EU member states. But let us look at Portugal, which again, according to the conventional wisdom, you mentioned that there were a few cases in the past, but they've been used as a shield. But as a sword, let's say, actions were very, very few. Maybe even if they were some, they were undocumented. And often when people in our cycles talk about Portuguese competition law, private enforcement of in Portugal, it's immediately we think about you, because you've been the Sisyphus moving this well, at least I'm talking about the reflections, our understanding of things from pure observational perspective. So you not only describe these issues, you not only analyze these issues, you also are an actor. So please, where did you start? What were the main obstacles and main achievements?
Yeah. I mean, thank you for that compliment, but I think it's a little exaggerated to say that I'm moving this stone up the hill, especially because then that implies that the stone keeps coming back down and I have to go push it back up again. I would really hope that not to be the case. But I think that there's been a lot of people who have contributed to private enforcement in Portugal. And if you look at it purely in quantitative terms, there are certainly lawyers, and I'm thinking of one law firm in particular, thanks to the trucks cartel, that have a lot more cases of private enforcement in court than I have ever done. So it really depends on how you look at it, I guess. I think my main focus on this, or the reason why my name might pop up more, is because of the academic side, where I'm going around to conferences and talking about this, and so people get more familiar with the name. But it really is an area where no single law firm could ever be responsible for making it a significant field or a significant area of application of the law. It takes a body of claimant law firms working on this, and sometimes law firms that are sometimes on the claimant side, sometimes on the defendant side. The increase in private enforcement in Portugal after the damages directive, I think, results from the more favorable law, but from this greater awareness amongst legal practitioners. And I think it's a great example of Adam Smith's invisible hand. Everybody's pursuing their own selfish goals, and we all hope collectively that this will lead to an optimal allocation of resources in reacting to antitrust infringements. I think I played a very small part in that. I was one atomized agent playing amongst others. My one small claim to fame here might be that in Portugal, I represented the Consumer Association, who was the first to launch an antitrust consumer opt-out representative action. And we did it with third-party funding. In fact, that's what made it possible. I had to create a law firm dedicated specifically to this. Most of the work the law firm does is this, representing consumer associations in court in opt-out actions. And the reason this had to be done that way as a boutique practice is because no medium or large law firm in Portugal is willing to specialize and can have a reputation for doing this type of, we call them popular actions. And the reason that is so, surely in a medium country, and smaller countries would even be more so, I suppose, like a medium country like Portugal, is that it just creates, on the one hand, a lot of conflicts of interest with several of its clients because it's a small economy. On the other, even with the companies who are not involved in those class actions, they will very often not be happy to be working with a law firm who might in the future be suing them on behalf of consumers, right? Or that is creating an environment that they perceive as hostile to business, where if you do an infringement and you cause damages, then you have a popular action asking for those damages for consumers. So there's a lot of pressure from the business side on law firms to not do this kind of thing. I had to start a law firm specifically to have the freedom to do that. And it all started in 2019 when I went to a collective redress conference in Haifa, organized by my friend Ariel Flavian, who still organizes the Perfect Law conferences. And it was at this panel where I was speaking about collective redress in Portugal, and I was saying, we have the most claimant-friendly collective redress laws. It's a shame nobody uses them. And this was kind of my line as an academic at the time. It's great, but nobody's using them. And two things happened at that conference. One, I found out that there was this thing called Merix v. MasterCard and how it worked and how the funding had been done. And more importantly, the legal basis for that funding, which was a provision that didn't really say that you could have third-party funding. It said that the expenses of the claimant could be reimbursed. And then I looked at our law, at the law of private enforcement in Portugal, transposing the damages directive, and we had the exact same provision. And so that was kind of the light bulb moment where I said, well, wait a minute, if the English could interpret this rule in this way to arrive at third-party funding, what's to stop us from doing that? In fact, there's a really strong constitutional argument of access to justice that you should interpret it that way. So that was the first element. And the second element was that I remembered I was a lawyer, which is something that I was forgetting at the time. I was so into academia and doing that. And then I said, well, stop complaining that nobody's doing anything about it and just go do something about it yourself, right? And it wasn't easy because it meant either doing it fully pro bono, which would have been impossible because we need to pay economists to do the work correctly. And I might be able to do it pro bono, but a lot of people can't, and I needed to grow a team. So the greatest difficulty at first was to find investors courageous enough to fund cases in a jurisdiction where there was nothing saying you could have third-party funding, much suspicion of the courts, et cetera, but we did, and it worked. And it was the first step, and then many others followed.
This sounds like an amazing story for a movie almost. I recently had a conversation with Damian Geraden, and he mentioned that getting a third-party funding is not as easy as it might sound for the critics, because critics stereotypically perceive third-party funded litigation as a kind of rent-seeking almost endeavor, where you contact the firms which are super top-tier experts in almost venture capitalism or something of this kind, and they just invest looking at the opportunities. But what are the motivation? It's a philosophical question, which is beyond our conversation, of course. But getting this trust from the investors is a huge work. So how did you manage to establish such a heavyweight law firm in just being also an academic?
Yeah, I mean the law firm itself. We started with two lawyers. That's it. Now not even 6 years later, we have 18 lawyers. So it's still a small project, right? It's something that has grown But it's when you think about it in terms of the resources that the defendants' law firms are deploying, like our one law firm has about a third of the lawyers that one of the law firms working on our cases is using to fight these cases. And that's just one law firm. So we have to be very efficient. But you're absolutely right that people underestimate how difficult it is to get funding. It really isn't. And I think that the best way to understand that is if you put yourself in the shoes of an investor and ask yourself, would I invest in this action? Would I invest in this case? And most of the times the answer will be no. And it won't be no because of the merits of the case. Although, I'm not going to sit here and pretend that there aren't cases out there whose merits are a little shaky. Certainly in the more adventurous ones where we're proposing, claimant lawyers are proposing new interpretations of the law or stretching the boundaries of what antitrust was supposed to be doing. And for example, using antitrust in a GDPR case or something like that. But what I found that really surprised me when I was beginning, it was that funders are incredibly averse to risk. People think that they're like these risk takers, and they really aren't. They need guaranteed returns in practice. Of course, nothing is guaranteed, but they really go out of their way to make sure that their investments are done in a way where they can ensure that they get a certain percentage per year out of this portfolio of investments that they have, right? And that's their main focus. They're not playing around with their own money. So they will typically only invest in cases where the merits are rock solid, and their questions, especially in doing opt-out actions in Portugal, their risk is really about how long this will take and what will the court decide in the end when it comes to the funder's remuneration. That's really their question. Like they're not worried about the case losing. Of course, anything can happen, but they've done the due diligence on the merits. They're worried about will I get some money back, how much money, and when. That's their risk.
Let us move on. We will revert to sociology of the matter because there are a few questions which are really interesting, and you tell this story really in impressively interesting format as well, which is great for me to learn about these issues. But let us look to the numbers, so to say, and the latest updates, where we are. Maybe if you can give us some perspective about in Europe, maybe comparing with other jurisdictions, but mainly about Portugal.
Yeah. So I don't have obviously full figures for Europe. I think that if we talk about number of legal actions, Spain alone is going to blow everything out of the water, right? Because just with the trucks cartel and the car cartel in Spain, we have thousands and thousands of individual actions. Now, we can look at that as thousands and thousands of actions, or we can look at that as one action or one case, right? One case is the trucks cartel, one case is the car cartel. But certainly there are a lot of national infringements also that are now being litigated, namely in Spain, in Portugal, and if you it's certainly not a too far out thing to say that we now have at least 20 to 30,000 individual actions going on in Europe as a whole. If you talk about cases, yeah, I mean, Europe-wide in terms of like EU-wide infringements, maybe 10. I would have to go count them. In terms of cases that include national infringements, there we might be talking about at most 100, and that's probably being very optimistic. Probably a lot less than that. So it's not enormous. In Portugal is an interesting case because it shows the diversity of approaches that can be taken to these to managing how I'm going to get my damages. We have, for example, in the trucks cartel, we have about 200 individual actions pending before the competition court, with very little bundling of claims. And most of the bundling of claims that has been done has been ex post by the court itself. taking, one company filed for 5 trucks, another for 10 trucks, and you put those together and you have like 5 companies in the same case. But at the end, the competition court is still being asked to do the same trial, listening to the same experts and analyzing the same evidence over and over and over and over and over 100 times. And it's just not working. And you have to, this is not specifically a problem in Portugal, but you do have to ask yourself, what is this theater that we're all going through, that courts are taking up their time when we all know everybody's going to land at 5%. The trucks cartel has been decided over and over again. It's 5%. Why aren't companies settling these actions, and why do the courts keep getting burdened by having to do the same trial over and over? There's probably blame to go around for everybody here, because, for example, in the Netherlands, the situation is a little bit different. You had, as you know, massive bundling of claims, and so you have like 5 or 6 actions, and even those have been bundled together, and those relate to hundreds of thousands of trucks. So that reduces the burden on courts. Judges could possibly manage these cases differently, bundle them more, maybe do one case first and then use that case to decide. But there's also legal restrictions, and judges, especially in the first instance, are often hesitant to take innovative approaches or to be bold when they don't know if the appeal courts are going to allow them to do that, especially in procedural management things. It can be frightening sometimes to step outside what is commonly done. So that's about the situation, that we have 200 individual actions in trucks. A lot of the big companies of logistics in Portugal joined the Dutch claim, so different route that they took. And then you have other individual actions that have nothing to do with trucks, maybe 5 to 10. Not all of them are well known. And finally, you have the opt-out actions. And the opt-out actions started as consumer claims, but now we're also getting SME claims, because our law states that SME associations can also file opt-out representative actions. Although now, very recently, in July, in fact, a ruling of the competition court has kind of put that all into risk, into jeopardy, because we don't now really know what interpretation of Article 19.2 of our Private Enforcement Act will be adopted. The court defended an interpretation where, in fact, it wouldn't be an opt-out action. It would only be to represent the members of the association, which would drastically reduce the point, or eliminate the point. So this is we're fighting this step by step, hearing by hearing, and sometimes what we think about the law doesn't necessarily turn out to be exactly what we were expecting, or we have to appeal and then wait for the outcome of the appeal, come back down, and then continue fighting. It's been an adventure. We have about 25 antitrust popular actions going on, and these 25 actions, they're claiming about 10 billion euros in damages, which for a country of the size of Portugal is a lot, right? And this is just in the antitrust field. The opt-out popular actions are very different from the individual actions. They're different in terms of the aggressiveness of the litigation, in terms of the investment that both sides put into these things, at least when it comes to the funded opt-out actions. We also have some opt-out actions that are not funded, and it's a whole other question mark to know how the court is going to handle that. How are you going to quantify damages when the claimants do not have the money to pay economists, right? What is the court going to do? And maybe the solution in those cases will change the way we look at this litigation altogether, because maybe it's possible for the court to do it in a completely different way. We'll see. But I think what I've observed is that the courts have a naturally understandable human tendency to be much more demanding and cautious with the opt-out consumer class actions or SME class actions than they are with the individual ones. So whereas in an individual case where you're asking for a few thousand euros, the court might actually make it really simple on the claimant to get what it wants. in consumer class actions where you have third-party funding, where millions and millions are at stake, sometimes billions are at stake, the court is super cautious. And I think that there's, as a theory, that doesn't make perhaps a lot of sense to us, because we would expect the criteria to be the same. But from a pragmatic perspective, I think we all understand why that is so and why it's difficult for it to be any different. The main ingredients that have led to the situation are, we have consumer associations that have been created in this new age of post-damages directive, representative actions directive, this new age of wanting to wake up to collective redress. And these consumer associations have a different model than the traditional ones. They're not trying to get members. They're not launching representative actions and asking people to sign up with their association and pay fees. They're really just focusing on doing the legal actions, doing lobbying work, doing regulatory work, but getting their motivation from somewhere else than the traditional scheme of let's get members, let's get some funding, let's do information campaigns. This is the traditional model, right? And then the traditional model typically also involves some business activities like selling magazines. Or these new consumer associations don't have that, and so their structure from the beginning was designed to be lighter and focused on fighting for justice of consumers in courts. And they're typically made of professors, academics, or other people like lawyers, economists, who are very knowledgeable and very focused on this goal. The other ingredient is specialized claimant lawyers. That really makes a difference. We've had so many cases in Portugal lost, so many consumer cases lost, because lawyers just didn't know what they were doing, because it's a really specialized field. If you haven't done a popular action, you're going to find surprises, right? And even the old consumer associations, because they did not have access to sufficient funds, third-party funding, etc., to hire specialized lawyers, they ended up losing a lot of cases. And I'm not thinking only about Portugal, I'm thinking about all of Europe. They ended up losing a lot of cases simply because of small procedural errors, for example, that they did, that comes from not fully understanding the specialized nature of this regime. And then you have the opt-out, of course. Without opt-outs, and I mean, I think academics have been agreeing on this all throughout Europe, so it's not a problem of the knowledge not being there, it's a problem of the political will. Without opt-out, you're not going to get collective redress in any meaningful number out to consumers. Opt-in systems work only in a very small percentage of cases, and even in the cases where they work, these are the cases where typically damages are above €1,000, but even in the cases where they work only for a very small percentage of the injured people, never more than 5%. And finally, third-party funding and the rules on costs, right? So basically the economics. You have to have access to money to run these cases. Nowhere in Europe is there public money available in any significant amount to run these cases. So we're always talking about private funding so far. And the regime has to be such that it makes it viable for these this funding to be enough. So I'm thinking, for example, of the UK, where litigating can cost £30 million. The same case being litigated in the Netherlands would cost €6 million. The same case in Portugal would cost 6 million euros. And in Portugal, it would cost 2 million euros. This is huge, because it means that the type of claim that can be economically viable is going to vary drastically, depending on where you are and how much it costs. Yeah, and I think it's it. I think we noticed a boom in the beginning. And now what we're seeing is a stabilizing of the number of actions being filed. They're still growing, but at a stable rhythm. And the main reason for that is that I think people are holding their breath to see if the system actually works. The courts are still to deliver, and this is the UK, Netherlands, Portugal, the courts are still to deliver proof of concept, right? That the opt-out representative action with funding can reach an end and everybody gets their damages and the funder gets an adequate remuneration, and this works, and there's distribution, etc. Proof of concept is needed. And cases are taking so long that I think, and this is my main concern at the moment, I think that commercial third-party funding is being endangered because of how long cases are taking. And that's a very pragmatic, very practical concern that courts are usually not very interested in, but it could dictate the success of the regime in the long term.
So my next question is partially referring to the latest point which you have said, but it also has a broader aspect as well. Namely, because we understand when the stakes are high and the defendants are super qualified and they continuous relationship with top tier law firms and economic consultancies, and they know 1,001 way to complicate the things. So I wanted to ask you about the complex economic evidence and highest standards of procedure, or the cost of procedural errors, which you have mentioned earlier in your answer in describing the situation. So I imagine these must be very, very high. So in the context of the latest point which you have mentioned, do you think that, or please reflect on this fact, whether it is the situation indeed, and B, whether the judicial systems, I wouldn't dare to say fit for purpose, but somehow are they still operating in the pre-digital mindset? Maybe there are some needs for, or are not necessarily judges. Judges are might be top tier in terms of understanding, but the procedural means to delay. And obviously, if you are an investor and you don't get return for the predictable period of time, you just next time you say no. That's quite clear strategy. So how do you think it's repairable, and what are the elements of this maintenance?
Yeah, there's a lot of aspects to that question, right? I think that let's start with the procedural stuff. I think that our judicial systems throughout Europe have shown themselves very resilient and adaptable to new technologies. For example, in Germany, we've seen artificial intelligence successfully deployed to basically automatize claims, the filing and management of claims in cases like trucks, but not only, where computers did it all. You know, the person would fill out a form, the computers would fill in the claim, submit the claim online through the digital platform of the courts, and then prepare instruction documents for the lawyer that had to show up in court and what he had to say, what he couldn't say. So the market uses the opportunities that it has and presents tools to the agents that need these tools, right? This has already been happening. At the same time, I think there are certain restrictions that are hard to surpass because they come from the law itself, and there's really not much that the courts or the market can do about them. And obviously, I'm thinking about the existence of opt-in, or even maybe some restrictions to bundling, doubts about assignment, which are now getting cleared up, thanks also to the work of the Court of Justice and the German Federal Court and many other courts. But these legal restrictions, in the end, I think some of them are going to have to be addressed by the legislators, especially the opt-in thing. But if we look at this broadly as a terms of as a perspective of the economics of this system working, we need to be clear about it's not a one-size-fits-all thing. We need to analyze the different cases differently. If you're talking about a case where the damage per injured person is 5 to 10 euros or even 100 euros. That's a completely different scenario than if we're talking about a case where the damage per injured person is 3,000 euros. And it's certainly a very different scenario when you're talking about large companies or even medium companies being harmed and they were harmed for millions of euros. These are not the same thing. And although we have to apply the same rules, well, maybe I shouldn't say have to, but so far we've been applying the same rules of burden of evidence, for example, and what do people have to bring to the table? We've been applying them equally to all of these cases. It's really not the same. And it's not the same if you're litigating a 100 euro case all by yourself, which would be crazy because there is almost no country in Europe where this would be economically viable, right? Typically, in continental Europe, at least, you will not recoup the money that you have invested in your legal defense fully at the end. So you need thousands of euros to be able to make it economically viable, and even then, you will never get fully compensated, which is a discussion for another day, right? Sooner or later, the court will have to be faced with the question: do national rules on costs comply with the principle of full compensation if people cannot get the money that they invested in their defense back, even when they were completely right and they won 100%, whatever that may be. Then there is, in antitrust, we have a specific problem, which I think you were also hinting at with your question, which is the issue of the quantification of the damages and the need for economists, right? Were you also getting to this, Olis? I wasn't. I don't know if you want to leave. Yeah. The quantification of damages, I think, has been one of the most unnecessarily complicated things that everybody has been obsessing about. I recently was at a conference where a distinguished economist, she said something, I'm not going to name her because I don't know if she would like to be named, but she said something fascinating, which is basically, she just told a room of lawyers and economists that, none of this is scientific. Let's stop pretending like we have no idea what we're doing. And, of course, it was a bit of a tongue-in-cheek comment, somewhat of an exaggeration, but in the end, she really did mean that economists could not provide a scientifically rigorous answer to the question, how much damage did this cause? And I think we all know that. I think we all know that because of the defects of economic theory in itself, the subjectiveness of it, but even if economic science was perfect, because of the insufficient amount of information that they will always be working with, right? And because it costs too much money to do the extensive analysis of facts and data that would be required to, to really apply the science in its full rigor. In the end, what we're doing with these exercises of quantification of damages is we are pretending to do rigorous quantifications. We are paying economists a lot of money, by the way, hundreds of thousands of euros, if not millions, to give an appearance of science to the approach that the courts are applying. And that's at best. At best, we get to feel better about ourselves as a society because the justice system isn't just saying whatever. It looked at the science and it said, well, I think I'm more persuaded by this than by that. That's the best scenario. The worst case scenario, and I think that's the one where we've been ending up a lot, is that we pay hundreds of thousands of euros to get reports just to tick the box that we did our best. We did our best. No idea how much damage this caused. He says 10, he says 0, and we always end up in 5%. Obviously I'm exaggerating. Not all cases have ended up in 5%, but it does seem a little bit frustrating that the way that we have handled economic quantification of damages so far is mostly a partisan way, that has made courts very suspicious of of how much they can trust the opinion of these economists, and that's not really where we wanted to get. So I think that what we should be looking at is how can courts take control of that quantification process themselves, resort to economists doing these quantifications that can be trusted by the court and not a partisan process. Let's not look at the competition agencies. They want no part of this, so let's drop that idea forever. But some kind of judicial system has to be found that doesn't entirely rely on the parties. And the courts have the rules at their disposal to do that. And the great part of this is that it would almost certainly be a lot cheaper if the courts were to do this, the kind of publicization of the way of quantifying damages. And so that would also make justice more affordable. And it could lead to answers to the questions, what about in small cases? How can we go about quantifying damages in small cases where it's just too expensive? It doesn't make any sense to pay these economist costs. Or it can even lead to a more clearer way of saying, at the end of the case, if you win your case, you won't have to pay economists. It's the other side that will pay the economists that were appointed by the court. So there are a lot of advantages to this system. What we cannot do is continue to accept this incredibly expensive rent that we're paying economists just to feel better about ourselves and have an appearance of science, an appearance of righteousness, when in the end we're all ending up in 5%. Then let's just do what Hungary, Latvia, Romania did. Let's just put a legal presumption in the books and get it done with.
The latest part of your answer somehow disavowed the significant part of my next question, but let me ask it yet. So recently I had the honor to talk to Guillaume Loriot, and he mentioned that the complex decisions on mergers of the European Commission by the European Commission is part and parcel of the system, because each aspect is just the decision on both sides is justiciable, and thus you have to defend yourself at the beginning rather than at the end, protecting all potential loopholes, hypothetical even loopholes. Just better safe than sorry. So you build up the house very, very heavy bricks and stones. A. B, the issue of economists, yeah, and snake oil stuff, which we all somehow feel very enthusiastic on legal side because it somehow meets our intuition and observations from the past. But this same or similar can be mutatis mutandis, perhaps said about lawyers and our obsession with procedural fairness and references to constitutional values, etc. So you can complicate the story. You can, from different glosses of case law of the past and from all the constitutional provisions, principles, you name it, you as a defendant, as a super heavyweight, super fit lawyer, you can use these ingredients in almost frivolous fashion. Again, I also exaggerate, but and thus it leads us, or at least many of us, to a conclusion: is it resolvable, or we have to adapt and operate within the system where we are doomed to carry this heavy burden of proof, standard of proof, and yet the last part of your answer reflects that there are some lights of optimism, because there are simple, quick and dirty tools which would not resolve this conundrum, but at least make it simpler and less heavy, so to say.
Yeah. No, I think you're spot on, and thank you for that, for mentioning that, let's not forget the lawyers, right? Because I think that yes, economists can be a pain sometimes, but nobody can be as much of a pain as the lawyers in litigating these cases, both sides. There is I think it's a cultural problem. It's a cultural problem which is in the hands of the courts to change. And so far, I have seen no willingness to do so. I've seen some remarks in judgments here and there, some criticism. Oh, you shouldn't write this much. Oh, you should, be more moderate, etc. But They have tools to control all of this, the courts. Every single legal system gives them tools to do that if they want to, and they're simply not doing it. And the tools can be something, it can be very, very simple. It can be you submitted a 500-page defense or a 300-page claim. I don't want that. I want something short. You know, if you can go to the ECJ and write 40 pages or 20, then you can do that here. So let's do something short. Or listen, you're arguing 30 different reasons why this case should be thrown out. Let me tell you, I'm going to look at all these reasons, of course, because that is my obligation. But if a lot of these reasons I think are completely unmeritorious, I'm going to start fining you for it because you're just wasting the court's time. Or at some point, it becomes just bad faith litigation. You know, and this is for both sides. If you file a claim that I think is totally unmeritorious, you're going to get fined for bad faith litigation. If you submit arguments to me that I think are just wasting time, if you say things that you know are untrue, you're going to get fined. You're going to have to pay costs to the other side, etc., through bad faith litigation. These tools are available. Courts don't use them. It's extremely rare. We don't have any findings of bad faith litigation, basically, in any antitrust case in Portugal. And there is this idea that you really need to allow parties to say basically whatever they think is important for their defense. And we have an expression in Portugal we say that we throw the clay to the wall and hope it sticks. Right. And this is a strategy that you can use or not, but if you use it, there is no consequence whatsoever. So I understand why it's tempting, especially if you're on the defense side, to say anything and everything and to throw everything at the court. Because why wouldn't you? Maybe you get lucky, and if you lose, nothing happens. This is where, you know, law and economics really needs to come in and give the judicial system a hand. Just you have to think in terms of economic incentives, and I'm not thinking just money. I mean, economically more broadly, there should be consequences to taking up unnecessarily the court's time. Otherwise, people will do it, right? And this could also be used as a way of shaping the future of access to justice, where you create the incentives that cases are presented in a very succinct way. They're going to be handled in a structured way. One of the problems that we're having is that courts are not deciding, and both parties, both sides of the dispute are unhappy about this situation, where courts are not deciding basic issues of the litigation at the start, but they're pushing them until the end. Things like limitation period, things like, do you have standing? Sometimes the decision on standing is pushed to the judgment at the end, which is like, well, why did I have to litigate the entire case to find out if I had standing? I mean, surely that will be somewhat annoying, to say the least, if we've spent hundreds of thousands or millions of euros and at the end you say, oh, I could have just decided at the beginning that you didn't have standing. So I think that the tools are there, the tools are available, but I don't think this is, ironically, I don't think this is one of those things that the law can easily solve. It can help, but it really is an issue of having judges speaking to each other, developing a culture and a system where they know that it's okay for them to be more hands-on. It's okay for them to be more courageous and use the tools that they have in front of them, right? That's not going to be punished, that's going to be well received in appeal courts, etc. So the message could come from the top, but I think inevitably it's going to be some courageous first instance judges who are going to have to start doing that and seeing how the appeal courts react.
Recently, in a private conversation, a famous German academic has shared his experience of talking to German judges who adjudicate on competition cases. And he was very perplexed to learn that they are not particularly, from judging from his impressions about this kind of conversations during coffee breaks, that they are not particularly enthusiastic of their cases being either published, but that's probably a must in German, or systematized. We know of some academic initiatives, at least I know from my past, our friend Sebastian Peyer, who was doing his research trying to systematize German private enforcement before it became mainstream. Probably there are other initiatives, more recent initiatives, but it's been done on academic enthusiasm. Whereas in this day and age, it's a matter of one click, metaphorically speaking, to systematize this issue. So is this uncertainty, we can only speculate, is it because, if it is it there? Is it because the system is very in its kind of very early stage of growing, and thus they don't want to make any mistake being somehow instrumentalized and used against them in future cases? Or what are the explanations of this, if this is a trend?
It is definitely a trend. We're seeing that in Germany. We're seeing that in Portugal. We're seeing that in Spain. Those are the jurisdictions that I follow. It is so difficult to have access to, as an academic or as a practitioner, to have access to the precedents that you have in the first instance, especially of these antitrust private enforcement disputes. In Portugal, we, for example, have no public database of first instance decisions, even though the government about a year ago said they were working on it, but we still don't have it. And for example, in Spain, my good friend, Professor Francisco Marcos, has been, doing this Herculean academic effort of compiling all the trucks cartels judgments, which are thousands and thousands, and summarizing their results so that we have some kind of statistical overview of what exactly is happening. And it's super interesting. This could all be done much faster if we just had a public database and we could use AI to extract the data. But the public databases are, even in Spain, where they do publish a lot of stuff, they're still incomplete. And I wouldn't know. I mean, I have suspicions, but they're just suspicions. So I wouldn't want to say why judges don't want their decisions to be public. They certainly, I think that they would welcome systematization. They just perhaps are not as excited about the publicity of their own individual decisions. So, for example, one of the, and you know this, Olis, I love empirical studies. This is mostly what I've been doing now, and I'm working on a project at the moment where I'm trying to precisely systematize all the popular actions in Portugal and all the civil popular actions in Portugal, and say, well, what have been the legal questions discussed? Where have the courts landed? I think courts will enjoy having that as long as it's anonymous, meaning you do not identify the judge. And that was an interesting lesson. That this might, it doesn't answer your question, but it does give it a little bit more logs on the fire. I learned this issue the hard way when I was at a conference at the School for Judges in Portugal. And I was talking about a previous judgment, a case that was res judicata, so it was over. And I mentioned the judge who had delivered it. And someone came up to me at the end and said, you shouldn't have done that. You shouldn't have named the judge. I found that very surprising because for me, judges are a sovereign body. The court is a sovereign body, and there has to be accountability, which starts with knowing who did it. Yeah, but there was a message clearly passed, and I think it is an installed culture of it's the court, it's not the person, it's not the name, which makes it hard to be accountable. But let me add something on top of this, which is to say, there's someone else who even hates accountability even more, and that's lawyers. I think one of the most interesting work that could be done, rather than saying, oh, which judge decided this, which judge decided that, is which lawyers argued what. That would be, and that's probably my second edition of level of empirical work that I'd like to do, because the judgments are public, but and sometimes you can hold accountability to the courts because of their public, even if you have to go get them, etc. But what lawyers argued is a lot harder to find out, right? And that allows lawyers to argue one thing and its opposite in different cases, which I always found, like, if you're an officer of the court, how can you be arguing two different interpretations of the law depending on what suits your client? This is surely not an attitude, and most lawyers would disagree with me, I think. But this, for me, is not. You can argue it in the abstract and say, well, there are those who would defend this other position, but you can't make a personal strong case. I believe that this is how the law. No, you just said in the other case that you believe the opposite, right? So, yeah, go ahead.
I'm sure they will refer to Heraclitus, and that if two people speak about the same thing, it's not the same thing, all this stuff. But it looks that I interrupted you. Sorry.
No.
So I wanted to ask you, moving to the end of the conversation, about the private and for or your observations, not even expectations or predictions about the DMA and maybe its UK equivalent. So moving to the things where basically the obligations have been made according to, well, I think intentionally too demanding in order to facilitate public enforcement, to give the extra injection of vitamins, let's say, or energy to public agencies to mitigate a little bit these misbalances of resources, etc. In my view, if we have super fit and well-trained private litigants taking over on this low-hanging fruit, this might diminish the power of this sophisticated public enforcement of DMA. So this view is definitely in minority. It's a rather heterodox opinion. And the majority would say that the more the better. The more harm is being avoided or the more punishment is being delivered, the better it is for Europe, let's say. Maybe reflect upon this normative aspect, but also what do you think technically? Will we witness a lot of litigation, private litigation on the DMA?
No, at the moment, I don't expect a lot of private litigation on the DMA. I think the main driver of it will be business to business disputes, which is what started this in the first place, where some businesses will use the vast resources that they have to fight other businesses with vast resources. I think that, as always, the poor cousin in all this is going to be the consumers, where you're going to have very few cases based on DMA protecting consumers. But you said something that I found very, very interesting, which is that this idea that you would have the private litigation taking up the low-hanging fruit, and that would somehow deprive the public authorities of some of their power or some of their perhaps impact. I can't really imagine how that would be so, because one of the things that I've been discussing now is, can you have, for example, an EU-wide injunction, a private enforcement EU-wide injunction? It's not clear. And for discussions that you're having at the European Court right now in other fields will impact this. For example, in Apple app, which is about collective redress and where can you file it? Do you have to file one for the entire country in a court, or would you need to separate them and you go like all the different courts in the Netherlands or all the different courts in Portugal to cover the entire territory? But one of the questions that is not being asked in that case is, what about injunctions? Can I go, if I want an injunction against Google EU-wide, do I have to go to 27 member states and ask in each national court for an injunction? Or can I go to, or do I need to go to Ireland and ask for an injunction in Ireland for all of Europe? If that is the case, then yes, you could have some private actors, businesses, but also consumers, taking some of the sphere that we would expect these regulators to have, right? That's where I see more this scenario more playing out, where if you give the private sector the tool to do EU-wide injunctions, that will be a strong incentive to do that. Although there will be huge economic obstacles to it, because you can't make money doing in most of the jurisdictions, you don't even get back what you invested in your lawyers doing an injunction, in most, probably all. So it will still be very challenging, but there might be altruistic funders, or there might be pro bono lawyers doing it. I don't know. There might be something. Whether or not people will have the money to pay the risk of the adverse costs on the other side, that's a whole other discussion, right? So I don't know if it will be economically viable. What I think I do know is that even if these injunctions were to happen, the regulators have control in the end, and they can put a stop to it, or at least they can put a pause to it. Because what we've seen in antitrust proceedings is that courts are very, very eager not to step on the toes of regulators, and to allow the regulators to decide instead of the courts. And so even if you have an action that is filed before any regulator takes action, if the regulator, national or European, if he decides, I'm going to do something about this, even though there's already a case pending, most likely that court is going to wait. So I think control is in their hands.
That sounds very, very convincing. Let us pause here with private enforcement and move to the last part of our conversation. I wanted to ask you about your academic life. I remember, I think it was either pre-COVID or during COVID, you have released amazing series of lectures on YouTube on private enforcement in Portugal, but it was broader outline and exposition, systemic exposition of the development of private enforcement mechanism. Your students must be very fortunate and grateful for your academic engagement as well. So I wanted to ask you, how much time do you spend preparing lectures and seminars, contributing, etc.? What is that would be a very broad part of the question. How does it feel about academic life in Portugal? Is it being in a kind of position of continuous challenge and reshaping as we see it in other jurisdictions?
Mm. I think I feel super privileged and grateful for the position that I have, and the way and the opportunities that it grants me, because I have been teaching at the University of Lisbon Law School since 2008, and it really is a position that allows me to mix what I'm doing in practice with what I'm learning and teaching in theory, and the two feed on itself. And I couldn't imagine a situation that is more stimulating than being able to have the framework to teach and discuss with students and do the research and publish, etc. But at the same time, being in the courts and figuring out how this actually works in practice, and getting so many surprises that the two often are not in sync. And so right now, I would say that I'm mostly a practitioner, just because the number of cases are getting so high that it's taking up a lot of our time here at the law firm. But at the same time, all the practitioner work that I do is, in a way, very academic, because we're discussing new issues. There isn't a single week that goes by where we don't have a novel legal issue that had never been discussed. And so I don't feel a clear separation between the two. I go, and I see you there often. We go to conferences all over Europe, and we talk, and am I using the lawyer hat? Am I using the academic hat? At some point, it's all just the same hat. It's all just me being constantly stimulated, incentivized, and pushed to learn more, to pass on that knowledge, and to get deeper into this. And I try to do that in a way that I think I learned. You probably know this, Alice. My great idol in this field is Richard Wish. And he has this thing where he will take the most complex issue possible and present it in simple words, like it's the most basic, obvious thing. And I try to do that. I fail largely to reach to the level that he is able to do that. But I try to do that in academia, and I try to do that in practice, because I think that that is the only way that you can truly get your message across. If you can push it down to something really simple, and say it in a way that anybody in a cafe, it doesn't matter, they don't have to be lawyers, but anybody can understand what you're saying, then that's how to pass knowledge along. And it's a very, very much a work in progress. But that course that you mentioned was precisely an example of trying to do that, where, you know, you don't focus on teaching antitrust to specialists, focus on teaching it to an Erasmus student who just arrived and has never heard about competition law, but you're going to discuss complex issues of procedural strategy and antitrust private enforcement, you know. And how do you do that in a way that is interesting and that makes them want to go deeper? So that's what I've been thinking, and I'll probably do a new edition of that course at some point.
But in the meantime, we will put the link to the current edition. Let's say once it's updated, please let us know. My last question is a tradition recommendation for students, but I wanted to maybe to give you an option, maybe to suggest something not only for me as a student, where should I position myself, but maybe also from your perspective, what is missing in the current rapidly evolving constellation of private enforcement in Europe. Maybe that we can imagine of some student startup where they can dedicate their efforts on a specific aspect of this evolving system, which requires a dedication, but also fresh approach to things, enthusiasm, and this opportunity to make mistakes, but also to learn from your mistake, which students are not often shy away, so they are ready to do these mistakes. So it's up to you, but either it's more individual or more kind of strategic recommendation.
Yeah, my main recommendation to students would be, don't rely too much on the books. Go to the law in action, read the case law, see what the courts are actually deciding, and then discuss that with other professors, discuss that with people in your field. Nothing beats seeing how the law is actually being applied to identify what your society is truly facing. What are the challenges? What are the obstacles that you're going to be facing as a practitioner? For me, I would teach classes only based on case law and never quote the opinions of authors if I could. And if you wanted to choose one area that is being perhaps underanalyzed, if you want to dedicate yourself to doing something that would have a gigantic impact in practice in antitrust private enforcement, my recommendation would be to look at access to evidence, because that is really proving to be the crux of why the legal system isn't working, for two reasons. One, because the culture is not following the law. There's just too much resistance in continental Europe to applying the logic of the system that has been put forward in the damages directive. But even in the cases where you do not have that resistance, other obstacles are coming along, such as access to evidence taking too long and leading to results which are perhaps not what you thought that they would be when you got the order for disclosure. And so it's super, super challenging. It's highly empirical work, but I think that there's a lot of academic work that needs to be done here before there can be a new legislative intervention to kind of try to give a better solution than the one that we currently have in the damages directive, which is a great start, but it hasn't been enough.
Miguel Sousa Ferro, thank you very much indeed for your really remarkable views and for sharing these views with us.
Thank you so much, Oz. It's always a pleasure to talk to you. Thank you.